All right, so we have a list of the top 10 questions people ask, at least according to ChatGPT, about orders of protection. Are you ready?
Sure, let's see how we do on those.
All right, the first one, according to ChatGPT, is what is an order of protection?
That's a good question. An order of protection is really a protective order against someone you are in a relationship with or you've had a relationship with, whether it's marriage or significant other, you have children in common, and it is used to protect you in the cases of domestic violence.
Does it stop a bullet?
No, it does not. Oftentimes, like we like to say at the office, it is a piece of paper that can be used to enforce that no contact order, but really it's up to then the police to make sure that it's enforced.
All right. But there's also injunctions against harassment, which is a different type of protective order that somebody might need if they don't pass the relationship test. So they're not married, they don't have a child in common, they don't live together, they were not romantically involved now or in the past. So it's important that people talk to a lawyer and figure out which one of these they need so they don't try to get the wrong one.
Right, because injunctions against harassment, you need a series of events, whereas order of protection, you only need one event. And as long as you've got one qualifying event, you are that will withstand scrutiny under the court's eye, then you're good.
Well, people would probably ask, even though ChatGPT didn't, what's a qualifying event?
Any type of domestic violence under the statute, there is, under the criminal laws, a wide variety of domestic violence. So it can include somebody who's hitting you. It can include harassment. For example, I had a case where opposing party was calling 40 times a day, and we were able to go to the court and go like, this is harassment, and the order of protection needs to be upheld.
And a lot of people think, well, they're just yelling at me, and it kind of depends on what they're yelling, right? If they're yelling threats, that's going to probably qualify you for an order of protection. If they're calling you a name, it kind of depends on what name it is, right?
Right.
So.
Exactly. You know, like people who come and it's like, well, they were mad at me and they said, well, I'm going to go out and do whatever, right? If it doesn't affect you personally, like it's not aimed at you, you know, it's like, which is different than I'm going to kill you, or you know what? If you want to live to see tomorrow, you're going to do this. That's a different type of threat then.
So ChatGPT wants to know, how do I file for an order of protection?
It's very convenient. The Supreme Court has actually made it very convenient. It is all online nowadays. And so you can search for orders, literally type in order of protection, azpoint.com, I think it's .gov, right? Will come up, and you create a login and a password, and you can type in all of the information that's required in that. You can also, which I find interesting and good, is that you can log out of it and it will save your information in case your significant other comes upon you and you don't want them to know what you're doing.
But even if you fill it out online, you still have to go to the court to actually ask the judge to issue it.
Yes.
And for people like me who are old and like doing things in person, people can still go to the courthouses. They all have a domestic violence or protective order or family protection center. I'm not sure. They each call it a different thing. And they have computers and someone to help people to fill it out there if they don't want to fill it out at home and then go in and pull it back up.
You're right, and people have to remember that it's not just Superior Court. You can get them in Justice Court, City Court. So really the only time it's required that you go to Superior Court is if you've got a pending family law case.
Right. Yeah, a lot of people don't know that. That's a good point. ChatGPT wants to know, do I need proof to get one?
Yes. Proof can come in many different forms, though. Sometimes, like the case where I was talking about the harassing phone calls, we actually entered in the screenshots of the number of calls and the duration of these calls that were just coming all hours of the day. Sometimes people don't have documentary evidence, but they have their testimony. Sometimes they'll have a police report that will demonstrate what it is that actually happened. Now, a police report obviously contains hearsay, and it's not the same as a conviction. But again, like if you have a conviction, I've seen that used in an order of protection case as well.
Yeah, I hear a lot of people say, well, I don't have proof, right? And we always have to remind them, your testimony is proof. It's just a question of how much weight the judge gives that. So when you go down to get it initially, I think a lot of people don't understand. When you go get it initially, the other side is not going to know that you've gotten it. And so the quote proof you need to bring initially is a lot lower than what you would need later at a hearing, which is another good question. So what happens if the other side, disagrees with the order of protection?
Then the court holds a hearing, and the court has to determine who to believe. And the standard of review is preponderance of the evidence, right? So it's more likely than not somebody's telling the truth and somebody's not. Or this set of circumstances warrants an order of protection.
I always explain preponderance of the evidence as the judge has to believe you by 51%. Just a little bit more.
A little bit more than the others. And so sometimes that's where your evidence comes into play, right? Though, because if my client is saying, look, he slammed the door or he slammed his fist into the wall, right? And there's a hole in the wall, and we present the picture. It's like, here, Your Honor, here's the picture of the hole. And my client testifies, it's like, yes, that hole was put there on April 30th, 2026 at about 8 p.m. or whatever.
Now, of course, it's not good if the other side has a video of you actually punching the hole in the wall yourself. So
that is problematic.
Yeah, that's why we don't lie on these things, right? Because the other side might have evidence, and the court will look at that too.
And I think that evidence-wise, the other thing that people often forget is that, and this is why it's good to consult with an attorney, is that the court can only look at what's in that petition, right? And if you don't have something in the petition, there is a way to amend it, but the court could limit that to that testimony, right? So, it's something to consider as well.
Well, once somebody gets the order of protection, they've filled it out online or at the courthouse on the computer, they go into the judge says, here's your order of protection. How does the other side actually find out there's even an order of protection against them before they ask for a hearing?
So, interestingly, orders of protection are served by law enforcement. And usually it's the sheriff's department if you're in Superior Court. Sometimes it can be city police if you're in city court. But law enforcement actually serves those. Injunctions against harassment are not served by law enforcement usually, unless you're indigent and can't afford process server. Then the process, in an injunction against harassment, the process server is serving it, and you hire that person to do that.
Here's one that I think people are probably going to be confused on because of the recent law change. The question was, how long does an order of protection last?
Well, that is, yes. It now lasts 2 years from the date of service. And so it has long-lasting effects if it can be upheld. Either the party doesn't challenge it or they challenge it and it gets upheld.
So what happens if an order of protection or injunction against harassment is violated? You're not supposed to have contact and they contact you. What happens?
So your obligation then is to call the police and report that. Oftentimes, I don't know that the police do a lot with those, to be honest. I mean, I know every jurisdiction's a little different. And so sometimes the police will say, well, they're not here now. Or, or a lot of times our clients are confused if they're the person getting the order of protection, because they'll say, well, or they're the defendant, in the order of protection, and they have an order of protection against them, and they'll say, well, but opposing party keeps calling me, so why can't I call them, right? There's no violation by the person getting the order of protection. It's only the defendant.
Well, and you also raised a point about sometimes the police will say, well, they're not here now. That's why it's so important. If there is a violation and the person is near you or calling you, you've got to call the police right away. If you wait 3 days to do it, nothing's going to happen. really is important that they call the police as soon as a violation happens, not, when they're mad at them 3 days later for something else.
Right, exactly, because then it's like, well, you waited so long. Why did you wait so long? Like, there's no evidence now.
So this question, I think I want to reword that. The question ChatGPT asked is, can an order of protection affect custody or parenting time? But I think really the precursor question to that is, can I put my child on an order of protection? Because we do get that question quite a bit.
Yes, you can file an order of protection and even an injunction against harassment against as on behalf of a child against a person. Now, there are some age limits on some of those. If they're under 12 on an injunction against harassment, you can't put them on. The only people that can put a minor child under the age of 12 as the plaintiff in a case would be juvenile court.
What I think we need to make it clear, there's a difference between if the defendant is also a parent of that child versus if the defendant is not a parent of that child. So why don't you talk about the difference there?
Right. So if you're getting, for example, an order of protection on behalf of a child against the child's other parent, right? A lot of times there are issues with that, especially if you have a pending court case. Sometimes the court will allow it, but when the court allows it, it usually has to be domestic violence against the child. They won't generally, although some jurisdictions will, they won't generally put the child on if they've just witnessed the domestic violence or they were in the other room. Usually it's the parent doing some type of child abuse against them.
Yeah, and we see people all the time try to get around the family court by, well, I'll just put my child on the order of protection and then I don't have to deal with family court. But the courts really don't like to put children on orders of protection as a protected person from the other parent unless there's pretty significant evidence and harm to the child, because exactly it impacts their fundamental rights. And the family court might not be able to change the order of protection if it's already been challenged and heard by the first court.
Right. I was just going to say, I think that is one of the important questions. If it's not on the ChatGPT list, then the important question is, when do you ask for a hearing if you're the defendant, as opposed to, do I just automatically ask for a hearing as soon as I get served with that, or do I wait? So I think that is, to your point, one of those important questions that I don't know if it's on your list.
It's not, and it's a tricky issue. Even lawyers don't understand it a lot of times. People need to know, if your child's on that order of protection and you challenge it in the order of protection court and lose, your family court judge cannot change that. You cannot see that child for 2 years. And so the better practice is you've got to ask the family court to hold a joint hearing on both the order of protection and temporary orders so that the family court has authority. But, people without attorneys wouldn't think about that. They wouldn't know.
Right. I had a client the other day. They were just like, well, the paperwork says I can ask for a hearing. And so I asked for a hearing and I said, okay, so we have got 3 days to get the evidence that we need to try to get this injunction against harassment dismissed. The same with an order of protection, because they have to be held within a certain amount of time, especially if you're a married couple or significant other is living in the same place, the same residence as you, because there's that requirement that the hearing has to be held within 10 days of your request. And so if you're looking for police reports as part of your evidence to support your case, or a DCS record, or a teacher report, whatever it may be, then that should be taken into consideration. But I don't think a lot of times when you're pro per that you think of those things.
No, and other people don't think of, generally, if they're the defendant, the first instinct is, I don't want an order of protection against me, I need to go challenge it. There's not always a reason to challenge it, and there might be good reasons not to challenge it. If this is a person that you don't want to talk to anyway, it might not be worth challenging it and potentially getting that domestic violence finding against you. It might be worth just letting it be if it's not going to affect your job.
Right. The other instance is, oftentimes when the defendant will want to challenge it. And I had a case recently where I said, you are not challenging this until you see a criminal attorney, because there were criminal charges pending against him, but there were also criminal charges pending against the other party as well. And I said, you got to plead the fifth on this, because you did some things that could be considered domestic violence, and it can be used against you in a criminal case, and you don't want that.
Well, you raise an important issue when you talk about a criminal case. A finding of domestic violence through an upheld order of protection, it's not a crime. You're not a criminal now. It's not a misdemeanor. It's not a felony. You're not going to go to jail unless you violate it. But merely having an order of protection against you does not mean you've been convicted of a crime. And even an order of protection that's been upheld after a hearing is not conviction of a crime.
Right. It's not a conviction of a crime, but whatever he testified about under oath could be used in his criminal case.
Exactly.
And that is where the issue was in this particular case, is that he could testify about what the other person did that was domestic violence, but I was sure that the other party would then ask him about his acts of domestic violence, and he either would have to perjure himself and say it didn't happen, or say, yeah, this is what happened, or plead the fifth, which then none of it serves any purpose, especially if he was going to say what actually happened. And people don't oftentimes realize that. They see the movie or the show, it's like, I plead the fifth. And it's different. Pleading the fifth in civil cases is different.
Yeah, I do not think that word means what you think it means.
Right, exactly.
I'm sure that real live people have many more and different questions. Fortunately, they can always come see us over at the Law Office of SU and Seifert. We handle all types of protective orders and can answer all their questions and try to meet their needs.